my colleagues just now was talking about, I mean, the sort of the worldwide investments from China, and historically, I think China had been taking a rather passive approach in its sort of influence around the world. But now there's a clear shift, I think, from being passive to a very active role in sort of influencing across the region, around the world, and in particularly some sort of the regions where historically China had been allies with. So today, what I'm going to do is going to I'm going to talk about that sort of to further the sort of goals, the China's BIR initiative, that how and whether China has set up the necessary infrastructure domestically to attract and promote its own dispute resolution platforms to resolve these sort of disputes arising from the BRI projects. I will talk about primarily four developments. One of them, obviously, if any of you has gone to the Hong Kong Arbitration Week or the subsequent China Arbitration Week, please refrain from screaming because that has been talked about extensively. And I will talk about the mutual arrangement between mainland China and Hong Kong and in support of each other's arbitration to grant the court would grant interim measures in aid of the arbitration. Secondly, very recent development on the China's free trade zone in Shanghai that would allow foreign arbitration institutions to set up its own branch offices within the FTZ zone in order to administer cases. So that's some development that had attracted also a lot of discussions as well. And thirdly, I will talk about briefly on the China's International Commercial Court, which is an effort to in a way compete with arbitration, but also create a sort of innovative platform for dispute resolution. And fourthly, in connection with the China's International Commercial Court, China has been very welcoming and open to enforcing foreign judgments since the past 2 years. So firstly, I will talk about the mutual arrangements. For those who are not familiar with the mutual arrangements yet, it's essentially a bilateral arrangement between China and Hong Kong, which are two separate jurisdictions to support each other's arbitration proceedings. The historical position has been that in China, in order to get a Chinese court's interim injunction, you would have to have an arbitration proceeding conducted by the Chinese arbitration institution in China, and ad hoc arbitration is not allowed in China. But now that position has changed. Now that the Chinese courts would be able to grant interim measures in support of Hong Kong-seated arbitration, but also it doesn't include ad hoc arbitration. It includes the often seen commercial institutional arbitrations, including HKIAC, ICC Hong Kong, CTAC Hong Kong. And that's not an insignificant victory, I think, for the arbitration practitioners, especially in Asia, because then we have seen that very tangible results, very immediate actually, results in the sense that after only 10 days, this mutual arrangement was put in place. HKIAC has reported they have received 5 applications already to seek PRC court's interim measures in support of Hong Kong seated arbitration. And actually our team right now at Fangda, we are in the process of trying to obtain one PRC court interim measure to support one HKIAC arbitration ourselves. So we are very hopeful that we should be able to get the interim measures quite quickly. And in terms of the further development, also in the sort of arbitration week, other arbitration institutions, including our best friends from Singapore, had been calling for some sort of development in the Chinese regime to support other foreign arbitration institutions, including ICIAC, which is another popular institution for China-related arbitration. So that remains to be seen that whether China would be open to expanding the regimes that much. And this is clearly, the arrangement is very much consistent with China's more and more increasingly welcoming approach to foreign arbitrations and arbitration institutions. And the second development I was mentioning was the FTZ free trade zone, the arbitration. Historically, what we had was like foreign institutions such as HKIAC and ICC, they all have their own branch offices in China, but their role was very limited in the sense that they were only allowed to do training and marketing activities within China. They could not administer cases. But now with this new pilot plan, presumably that the foreign arbitration institutions within the FTZ would be allowed to administer cases. One of the more recent development was last month, the Shanghai Bureau of Justice had issued a notice which essentially set out the requirements of the foreign institutions that would be eligible for this arrangement. That would include, basically, you have to be established for 5 years, and you have substantial experience in handling this sort of arbitrations. So I think those would be quite encouraging for example, ICC or HKIAC to be able to administer cases within the FTZ zone. However, I think, being the practitioners, the devil's already, always in the detail, in the sense that if you think about how this is going to work, there's going to be a lot of question marks that to see how this is going to be implemented. One issue is, for example, originally, as I said, only the China-seated arbitration and institutional arbitrations would be able to, you would be able to seek the interim measures from a Chinese court. But now that with, let's say, an HKIAC arbitration in Shanghai Free Trade Zone, whether that would allow you to be entitled to seek the same sort of interim measures from Chinese court is a question mark. Secondly, in terms of the enforcement of an arbitration award, right now the Chinese court system now allows a party to seek enforcement of foreign award, but you have to firstly go through like a recognition phase, and then once it's domesticated, then you can enforce it. So in that case, then if it's a Shanghai FTZ zone arbitration, whether you need to go through that recognition phase is another question mark. And another more nuanced question probably would be, well, now with the ICC rules or HKIAC rules, whether you would be able to adopt completely those kind of rules in the Shanghai FTZ zone. As we all know that the Chinese style, more common civil law background sort of arbitration is slightly different. As to especially evidentiary rules, as well as how you cross-examine witnesses and such, those will be different. So how those issues will be tackled with is still a big question mark. The third development is clearly one of the top priority of Chinese Supreme Court during the past few years, because they have invested heavily in trying to set up this international commercial court, and they have been very aggressive in marketing this idea. To put it in short, essentially it's a body of judiciaries that would be designated to hear very significant and high-profile cases. The jurisdictional issue, that what kind of cases would be subject to the jurisdiction of this commercial court, actually is unclear. I have actually spent 3 hours in my office right after this notice came out to try to figure out what exactly kind of the disputes would be included in this CICC's jurisdiction. And then after that, I couldn't really reach a clear conclusion. So, very secretly, I went to another partner's office and wanting to talk to him about it so that I don't really embarrass myself in the public. And then he sort of had the same feeling of mine. So that increases my confidence that he's a very smart lawyer and he still can't figure it out. But in short, I think that gives the CICC very much discretion on what kind of cases they wanted to hear. Because one thing is, it says clearly that for the type of cases that has a nationwide impact, or any case that they feel that it may be appropriate for them to assume jurisdiction, so they can assume jurisdiction. And there had been currently 11 cases have been handled by the commercial court. We had a public hearing by the end of May this year. It's broadcast online. One side note is Chinese courts, in order to increase the transparency, had launched this program to require all Chinese courts to basically broadcast online its hearings. So as a Chinese litigator, I think that's a good thing for us, because right after that, I mean, the most obvious change is the judges would be a lot nicer to you. So that's quite a welcoming thing for us. But the more importantly, I think later this year, the CICC had issued its first ruling, which is a very interesting issue because it involved the review of validity of an arbitration agreement. This was not clearly in the sort of the jurisdictional scope of CICC under the law, but clearly the CICC had invoked the catch-all clause to assume jurisdiction on this issue. Again, that indicates that the CICC, when it feels appropriate, they may just decide to chime in and hear cases. Well, that could be good and bad. One thing is, I mean, for a lot of companies that they're not familiar with the Chinese court system or Chinese judiciaries, they may worry that whether that the CICC would just take on cases where it's not necessary, and perhaps there will be other factors in the play to affect the outcome of the case. And I think CICC, in order to sort of mitigate or partially address that concern, has set up also a panel of international experts that had been, they included a very prominent practitioners as well as academics around the world. But there have been critical challenges to those committees saying that, well, now their role is rather limited because they only are there to either mediate cases or provide some sort of counsel advisory opinions on foreign law, but they are not able to sit on the bench to hear the cases. Finally, and this is my favorite topic, I will go very quickly. I know that Johnny has been staring at me very angrily for the past 5 minutes. So related to this commercial court development, China, because I mean, traditionally we all understand that when you think about the pros and cons, litigation versus arbitration, obviously for litigation, one downside is you're not able to enforce it in a lot of different jurisdictions. Well, China now is trying to, in an effort to trying to fix that issue, has been very open to enforcing foreign judgments. There has been a Singaporean judgment that had been enforced 2 years ago. And we have, and Fangda has successfully enforced the US judgment last October. And that's considered quite groundbreaking because China and the US, the historical sort of position had always been it's not going to happen, it's not possible to enforce a US judgment in China. And subsequent to that, there is a Korean judgment also being enforced by the Chinese courts. And we are also monitoring, there's potentially another case that involves a UK judgment that the Chinese court is going to enforce. We have seen some very encouraging signs, fingers crossed. So as an effort, as I said, I mean, to promote the sort of the commercial court, China has taken the step of enforcing foreign judgments. So I think that's something that I wanted to conclude today my session with one sentence basically saying that I want everybody to be aware of this new development and sort of the historical kind of belief that it's very difficult or impossible to enforce a foreign judgment in China. That view clearly has changed. So whenever you encounter an issue that may potentially benefit your client to explore this approach, it's worth exploring. Thank you very much.